Hello, hello. Hey, try me. How are you? Good to see you. Good to see you. Yeah, this was quick. I decided I better just do it right now because I'm going to come back on later today, but I wanted to go over this stuff because there's some new stuff in Lori's trial, which is starting next week. Jury selection starts on Monday. And of course, she's up to stuff. She's doing her lawyer thing, filing stuff, but Nate Eaton did respond to um, being on the witness list. So I wanted to go over that for sure because that's really that's not gonna be good if he can't attend the trial because he's on the witness. He's a witness. He did say that even if he's not subpoenaed, if he's on the list, he won't be able to go. He won't be able to attend the trials. So it's pretty messed up. Um, Lori has some issues with the state's list, which we do have the state's list now. We do. Yeah, actually, a lot of this stuff is in here. Let's play this and we're going to show you his response. And I hope he gets out of that. That'll be so frustrating. Oh, and I've been working on a project. Not quite done, but I should be probably today. And I'll be able to show you guys something I've been working on for this trial. So they are pretty much anticipating like a week of jury selection. And opening statements on April 7th. So far, that has not changed. We do have as of this morning, or last night, I guess I looked. Let me see real quick. The other trial is scheduled. Hey. Yes, I want to wish a happy birthday to Mama's the Boss. So the next trial is supposedly, it's all running right together. It's got trial from 3:31 through 5:15. So I guess that's not the new one. That's what they expect this one to run. It's weird, a whole page of just trial. It's kind of different the way they have this up here. But I don't know what this means. This was today, pre-trial conference party. I don't know. It's crazy. I know, right? Yes, happiest of birthdays to Mama. All right, let's see what Nate says about everything right now. Let's see.
Our team will be here, and today we have a lot to discuss about the Lori Vallow trial in Arizona, which starts in less than a week. Jury selection begins Monday, and
I'm going to go some days.
It sounds like a lot that needs to be done. I'm Nate Eaton. Thanks for being here. Let us know where you're watching from. If you have any questions, we have a full docket today. Here's what we're going to be
at least 1 or 2 days.
It's the case why she says the prosecutor has been doing some bad things in Lori's eyes. Plus, we have the prosecutor's response.
Yes.
We have the state's witness list. We now know who the state is going to call at this trial. We heard about Lori's witness list that came out a week or two ago. Well, now the state has released their list. Lori has filed a motion to exclude witnesses from the trial. I have state's witness list on there twice. As you can see, we're really going to cover the witness list just to be sure you know all the witnesses. More filings from Lori, the trial schedule, what happens next, and in just a few minutes, Peggy will be here. Peggy, our comment moderator that many of you have never seen or met, we're going to bring her on. She's going to join us here and tell you how you can stay up to date on the trial, and if you have a question about the trial or what.
Yeah, we're going to have to make it fun. Some kind of, I'm going to come up with something good. Some kind of game. Like the whole thing. She's making the whole thing a game, actually, which is irritating.
Whatever, information you want about the Lori Vallow trial, she'll be here to talk about it. So, a lot to talk about tonight. These are just some of the motions that we're going to go over that Lori Vallow Daybell has filed and that the state has filed. There's a lot. And normally, well, I shouldn't say normally, in the previous case in Idaho, most of these motions were filed earlier. Actually, I shouldn't say that because Lori Vallow wasn't representing herself. It seemed that a week before trial, most of the motions had been filed and were done. And that seems to be, there's a kind of a last minute rush here with these filings. Mainly all because of Lori Vallow representing herself. She has filed motions that she believes, the trial should be dropped, that certain witnesses shouldn't be allowed to testify. But remember, she also does not want to waive her right to a speedy trial. She wants this trial to happen right away. And it is scheduled to start, as I mentioned, jury selection begins next week. So let's jump into the first filing that we're going to talk about today. This was the motion for her to dismiss Trina K, the prosecutor, for misconduct in Lori's eyes. You can see here, the defendant, Lori Daybell, hereby requests that both case numbers listed above be dismissed for prosecutorial misconduct committed by the state's attorney, Trina J. K.
Can you believe this?
So she mentions two cases. For those of you not familiar, the case we're talking about that goes to trial next week is the death of Charles Vallow. She's facing a conspiracy to commit murder charge there. A separate case is the attempted shooting of Brandon Boudreaux, her former nephew. That one will go to trial in a few months. She's saying that Trina K, who has been the prosecutor on this case with Maricopa County, should be dismissed because, in Lori's eyes, she says it is all about prosecutorial misconduct. So what does she allege that Trina K did? Well, we have it right here. On or about September 6, 2024, Trina K directed the Chandler Police Department and the Gilbert Police Department to refuse to provide public documents to the defense, interfering with the defendant's right to conduct an investigation. So Lori's saying that
can you imagine that they directed them to, how ridiculous is that? Hey, Two Skulls. Hey, birthday girl.
She wasn't given documents that Trina told the police departments, Gilbert and Chandler, to not give her documents. So that's the allegation and count in number one. Number two, on or about January 30th of this year, Trina K obtained and distributed attorney-client privileged communications between the defendant and her appellate attorney in Idaho. Lori is saying that Trina K got information that she shouldn't have, messages or communication between her attorney here, who's handling her appeal, and Lori herself.
Mess hair.
And number 3, that on or about March 11th of this year, Trina K gave legal advice to defense witness Nate Eaton in a, quote, off-the-record conversation regarding how to avoid being served with a subpoena from the defense.
Isn't this funny? Look at how, like, she knows this, right? She is so delusional, I'm telling you. What a complete shit show she is. Hey, Tough.
K has personally thrown her ethics and duties out the window in order to win this, quote, high-profile case in front of a worldwide audience. Lori goes on to say, because this court has ignored the state's conduct, Trina K became more blatant in her disregard for her ethical obligation. This is sadly similar to her longtime boyfriend, Juan Martinez's behavior in a, quote, high-profile case years ago here in Maricopa County. It seems her behavior is not original. The court is obligated to discipline officers of the court for misconduct. This conduct is egregious and needs to be addressed by the court.
Right.
The actions the defendant is seeking this court take are as follows. 1, removal from both cases. 2, sanctions. And 3, disbarment by the state of Arizona.
Oh, my God.
So these are big allegations. Well, these are big penalties that Lori is calling for. And she's making it personal by bringing in Trina K's boyfriend.
Congratulations.
Juan Martinez was worked on the Jodi Arias case years ago in Maricopa County. Now, I want to tell you that, well, actually, I'm just going to let Trina K respond because that's exactly what she did.
That is great news. I'm so happy to hear that. That is absolutely wonderful. You're totally right. I love it.
She says the state of Arizona, through undersigned counsel, requests this court deny her motion as there has been no prosecutorial misconduct. The state responds to each of the 3 allegations by noting that, quote, the facts as alleged by noting the facts by the defendant as to each issue. Number 1, on September 6th, the state became aware that the defense had made a public records request to the Gilbert Police Department. The state emailed defense counsel and asked them to request these items from the state. The state also requested that the documents listed in the defendant's public records request from Gilbert. So they requested these documents that Lori Vallow Daybell wanted. When the state obtained the documents the defense requested, the state disclosed them on October 1st as, I think that means date stamped pages, maybe it means bait stamped pages, 1,000, On September 18th, the state became aware that the defense had made a request to the crime analyst section of the Chandler Police. The state was advised that the defense request was improper because it was made to the crime analysis section rather than going through the public records request process. So, sounds like the defense requested the documents but didn't do it the right way. The state was advised the Chandler Police Records Specialist section spoke with Laura Moyes, who sent a request for, quote, log records for all digital devices downloaded. The state was also advised that the Chandler Police did not know what was being requested as, quote, log records. Chandler Police Record Specialist advised Laura Moyes that when computer crimes detectives are involved in a case, their reports contain downloaded information on all devices from Chandler Police. All reports related to the download of Charles Vallow's devices had been previously disclosed to the defense. Additionally, all extractions related to Charles Vallow's device have been disclosed. So the state's saying, what you're asking for, what you requested, they've been disclosed. You have them.
This is what we've heard the whole time. Pretty much that she said when she doesn't have something, they've said many times that they've given her everything. And if she can't send the request over correctly, it's just, this is a whole point of her representing herself. She doesn't know how. None of this is because she has any idea what to do. It's because she wants to parade around and make a show of this. You know, equally, I mean, it's just disrespect on disrespect, if you ask me. But isn't that funny how she brought up Juan Martinez? Do you guys remember Juan Martinez? He was a prosecutor in the Jodi Arias case. It's been all kinds of controversial stuff that's gone on around here about him. But I don't know a whole lot of it. I didn't pay a lot of attention to it. But he did a good job in the Jodi Arias case, I thought. I know. And I mean, the trial starts in a few days. The judge, when I was there, for the hearing I went to, the judge already told her even then, she's already past the time. That was what, March 11th. He told her she was past the time to be providing information and doing these things. She's still doing it up till now. She has no business doing this. So stupid.
September 19th, the state filed state's motion for defense to comply. On October 15th, the court issued a minute entry denying the state's request. The state is unaware of any other public records request to either Chandler Police or Gilbert Police by the defendant or her defense team. So Lori Vallow is claiming in that first point that they withheld evidence from her. The state is responding and saying, no, we didn't. The stuff you wanted, we gave to you. And there's nothing more. Point number 2. On February 6th,
Right.
These are about the jails, the allegations that Trina K withheld or read attorney-client privilege between Lori and her Idaho appellate attorney. February 6th, the state disclosed that jail calls made by Lori Vallow between October and January, as well as jail messages and photos from Lori Vallow's tablet from October to January. On March 18th, the defendant filed a motion to dismiss for violation of attorney-client privilege. The state is currently working on a response to this motion. The state hereby incorporates its response to defendant's motion to dismiss for violation for attorney-client privilege as part of this response. So it sounds like we're going to get something bigger on this particular issue. Issue number 3, the fact that Lori Vallow says that Trina K gave me advice on how to avoid a subpoena. This is how Trina K responds. On March 6th, the defendant filed a notice. The state requested that separate notices be filed for each cause number so the state would know which defenses and witnesses applied to each case. On March 7th, the state learned that defense noticed witness Nate Eaton is a reporter from Idaho. On March 12th, the defendant filed a supplemental notice. March 16th, the state filed a motion to preclude all witnesses on her supplemental filing. So that's a lot of words, but basically, the state filed a motion to have the people on that witness list precluded, not included to witness, to testify. At the final trial management conference on March 18th,
yes, it's 87 degrees here, actually. But I've been cold. Yes, exactly. It's making a mockery of it, Two Skulls, if you ask me. I really, it's shameful behavior is what it is. She doesn't know how to represent herself. She looks like an idiot, but she wants the attention. And look, to say that the prosecutor gave Nate legal advice, how would she know this? It's just ridiculous.
The court heard from parties on this motion. The state advised that it did not have contact information for most of the witnesses. The state also advised that one of the defense witnesses, me, was a reporter. Nate Eaton contacted this prosecutor. I missed the page there, sorry. Nate Eaton contacted this prosecutor after court on March 18th, and this prosecutor called Mr. Eaton back. Mr. Eaton advised this prosecutor that his knowledge about the case comes from his interviews and investigation as a reporter. Mr. Eaton also advised that he had not been served with a subpoena by the defendant and he hoped to be in court for the trial. The prosecutor advised Mr. Eaton that even if he was not served, he still could not be in the courtroom if he was a noticed witness and the rule of exclusion was in place. The prosecutor advised Mr. Eaton that this prosecutor would try to interview the witnesses and file a motion to preclude those that should be precluded at the end of the next week, which would be this week. The prosecutor did not advise Mr. Eaton how to avoid service of the defendant's subpoena. So what I can tell you based on both of those responses that Ms. K's response is accurate. For one, Lori Vallow Daybell said that on or about March 11th, Trina K gave me legal counsel. I have never spoken to Trina K in my life before March 18th. So that is wrong, on or about March 11th. I did say on Courtroom Insider that I had spoken with prosecutors and defendants. I did not say where those prosecutors and defense attorneys work, but I've spoken with several, not necessarily in Arizona or in Idaho or in other states. So we will see what happens with that. My hope and my plan, of course, is to go to this trial and to be there every day covering it. And there might be more to report about that angle coming soon. I have reached out to the defense attorney, Lori Vallow, and the defendant herself, Lori Vallow, about what more they might want me to testify about. And I have not heard back from the defense team. Okay, so that's one file. A lot there on the witnesses.
I know, right? Okay, so you got to see. So he did respond. I want that to be bigger. I'm going to try to make this bigger. Go back to that in just a minute. I know, me too. So, like, you know what happened. She doesn't. So she doesn't only say, it just kills me. She doesn't only say that, according to her, that Trina K instructed Gilbert and Chandler police to not turn over any records to her, which that would be completely ridiculous. But she also lays out what she wants her punishment to be. Like, really? It's just too much. Apparently, though, I guess that is, I know. Oh, Lord. You can't even make it up. I did not know that that was Juan Martinez's girlfriend, but whatever, you know. I don't even, what that has to do with Lori. It doesn't. Doesn't have anything to do with me. Doesn't have anything to do with Lori. Doesn't have anything to do with anything. It's just, that's her own business. Whatever. But she brings that up. It's just too funny to me. I cannot with her. Like, just stop. Okay, so this is Nate's response. Hey, Queen. Do you hear this stupid nonsense? She is something else. I cannot with her. It's Mama's birthday. Okay, so I can't for some reason blow this up. It's going to be hard for me to read, but okay, I'll back it up in a second. the penalties or whatever. It's absolutely hilarious. So Nate says, Nate, appearing pro se, files this emergency motion for protection order requesting that court strike his name from the witness list of the defendant Lori N. Daybell pursuant to Arizona Rule of Criminal Procedures or any other applicable law rule as follows. God, I can't see this. I learned that I have been identified as a potential witness by Miss Daybell for both this case and with the other one, which would be the Brandon Boudreaux. I am a reporter for East Idaho News and have no firsthand knowledge of information regarding the crimes of which Miss Daybell has been accused. My involvement in any matter related to Miss Daybell has been only as a reporter. It is my understanding that by simply listing me as a potential witness, I can be barred from the courtroom during Miss Daybell's trials. This seems to be a clear attempt by Miss Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. Such an effort clearly interferes with my First Amendment rights as a reporter and the First Amendment rights of my employer to view and report on the events of the trial in the same manner as any other member of the media. Thus, listing me as a witness results in a harm far outweighing any claimed usefulness. There is no legitimate usefulness to listing me as a witness. Further, the risk of harm cannot be eliminated, is that a word? By a less substantial restriction of discovery rights, as it is not the disclosure of my identity that is harmful, but the abuse of the rules of criminal procedure to list me as a witness in order to interfere with my constitutional protected rights and duties. Therefore, I respectfully request the court deny, strike Ms. Daybell's attempt to list me as a potential witness. So we'll see what happens with that. Clearly, Nate Eaton wrote that in response. So yeah, let me show you where she says. She is really something else, I tell you. Okay, I got to try to find. Let me see. Okay, I got to back this up. Let me see. Okay, I don't think that's it. Okay, no. Okay, right here. So, yes, they can. They can. If there's no reason for it, and there's not. For one thing, he can, like he just did, say, I want to report on this. This is stupid, right? And I don't have any information, right? I mean, does that make any sense? What could she possibly ask? It's like she just wants to ask him stuff, but she wants to keep him out of the courtroom. And I don't think necessarily, I mean, it's still going to be reported on by other people, but it's like a dig at him particularly, you know? So weird, right? Okay, so here's where she's talking about the prosecutor's actions. We already listened to this a minute ago, but um, I'm just going to play this last part again where, because Queen, she also says that the prosecution gave legal advice to Nate. It's just so damn funny. But in this, she'll tell what she wants to happen to her. I don't know why I'm laughing so much, but it's just that stupid. All the reason why you can't defend yourself because you don't know what you're doing. And she's still filing shit and it starts Monday. I mean, for fuck's sake. Okay, so here's yeah. Yes. Okay, right there. Seriously. I don't know. So I think right here is when I think this is the part here. Well, jury selection starts Monday. Um, they anticipate a week of that. The judge said he thinks they will start. Oh, just 1 second. Sorry. Um, he thinks that April 7th will be opening statements. Okay, you don't hear an. I have it on pause, but just makes me laugh the way Lori brought up Juan Martinez. Right here. See? Yeah. You don't hear does ever you guys oh yeah, does everybody else hear? Oh, son of a bitch. You guys. I'm not sharing it. Look at it's just me on here. I'm listening to it. Oh God. Ah, son of a bitch. Son of a bitch. No wonder I'm like, I think it's funny. Oh my God. Sorry. Son of a bitch, Jackie. I'm over here just laughing my butt off. Like, isn't that funny?
Misconduct. So, what does she allege that Trina K did?
Sorry.
Well, we have it right here. On or about September 6, 2024, Trina K directed the Chandler Police Department and the Gilbert Police Department to refuse to provide public documents to the defense, interfering with the defendant's right to conduct an investigation. So, Lori's saying that she wasn't given documents that Trina told the police departments, Gilbert and Chandler, to not give her documents. So that's the allegation in count in number one. Number two, on or about January.
Which really, I mean, that is seriously, again, she does, I don't know how she would know that. And why would anybody do that? So stupid. Everything she's doing is so ridiculous. Oh my God. I know. I'm like thinking everybody's hearing it. Shit. Sorry, guys.
January 30th of this year, Trina K obtained and distributed attorney-client privileged communications between the defendant and her appellate attorney in Idaho. Lori is saying that Trina K got information that she shouldn't have, messages or communication between her attorney here, who's handling her appeal, and Lori herself. And number three, that on or about March 11th of this year, Trina K gave legal advice to defense witness Nate Eaton in a, quote, off-the-record conversation regarding how to avoid being served with a subpoena from the defense. Ms. K has personally thrown her ethics and duties out the window in order to win this, quote, high-profile case in front of a worldwide audience. Lori goes on to say, because this court has ignored the state's conduct, Trina K became more blatant in her disregard for her ethical obligation. This is sadly similar to her longtime boyfriend, Juan Martinez's behavior in a, quote, high-profile case years ago here in Maricopa County. It seems her behavior is not original. The court is obligated.
That kills me. Bringing up Juan Martinez. Stop, really? Oh my gosh. Thanks, Two Skulls. It seems a little ridiculous, though, and nobody knows what the hell I'm laughing at. Oh, Lord. I really can't believe she did that, though. Bring up her boyfriend. Wow. It really is. She really is something else. Oh, my gosh.
To discipline officers of the court for misconduct. This conduct is egregious and needs to be addressed by the court. The actions the defendant is seeking this court take are as follows. 1, removal from both cases. 2, sanctions. And 3, disbarment by the state of Arizona. So these are big allegations. Well, these are big penalties that Lori is calling for. And she's making it personal by bringing in Trina K's boyfriend. Juan Martinez was worked on the Jodi Arias case years ago in Maricopa County. Now, I want to tell you that, well, actually, I'm just going to let Trina K respond because that's exactly what she did. She says the state of Arizona, through undersigned counsel, requests this court deny her motion as there has been no prosecutorial misconduct. The state responds to each of the 3 allegations by noting that, quote, the facts as alleged by noting the facts by the defendant as to each issue. Number 1, on September 6th, the state became aware that the defense had made a public records request to the Gilbert Police Department. The state emailed defense counsel and asked them to request these items from the state.
Yeah, I definitely think you should laugh at me too. I'm good with that. Yeah, it is, right? Yeah, seems that behavior is not original. Okay, well, I mean, come on. What a dumb thing to say about all of it. It's all stupid. That's weird. Like I said, I didn't know that was Juan Martinez's girlfriend, but I don't even need to know that. I think it's completely irrelevant. But she wants her disbarred. This is too much for me. Juan Martinez, he's the Arizona state prosecutor that prosecuted Jodi Arias. Everybody remembers Jodi Arias, right? That was crazy. That happened in Mesa, a town right here by us. Yeah. Remember Jodi Arias, defense attorney? Oh, okay. He's lost a ton of weight. Remember I showed you guys that a while back. I'm going to pull up some pictures of him, but I'll let this finish. Hold on.
The state also requested that the documents listed in the defendant's public records request from Gilbert. So they requested these documents that Lori Vallow Daybell wanted. When the state obtained the documents the defense requested, the state disclosed them on October 1st as, I think that means date stamped pages. Maybe it means bait stamped pages 1000. On September 18th, the state became aware that the defense had made a request to the crime analyst section of the Chandler Police. The state was advised that the defense request was improper because it was made to the crime analysis section rather than going through the public records request process. So, sounds like the defense requested the documents but didn't do it the right way. The state was advised the Chandler Police Records Specialist section spoke with Laura Moyse, who sent a request for, quote, log records for all digital devices downloaded. The state was also advised that the Chandler Police did not know what was being requested as, quote, log records. Chandler Police Records Specialist advised Laura Moyse that when computer crimes detectives are involved in a case, their reports contain downloaded information on all devices from Chandler Police. All reports related to the download of Charles Vallow's devices had been previously disclosed to the defense. Additionally, all extractions related to Charles Vallow's device have been disclosed. So the state's saying what you're asking for, what you requested, they've been disclosed. You have them. On September 19th, the state filed state's motion for defense to comply. On October 15th, the court issued a minute entry denying the state's request. The state is unaware of any other public records requests to either Chandler Police or Gilbert Police by the defendant or her defense team. So Lori Vallow is claiming in that first point that they withheld evidence from her. The state is responding and saying, no, we didn't. The stuff you wanted, we gave to you, and there's nothing more. Point number 2. On February 6th, these are about the jails, the allegations that Trina K withheld or read attorney-client privilege between Lori and her Idaho appellate attorney. February 6th, the state disclosed that jail calls made by Lori Vallow between October and January, well as jail messages and photos from Lori Vallow's tablet from October to January. On March 18th, the defendant filed a motion to dismiss for violation of attorney-client privilege. The state is currently working on a response to this motion. The state hereby incorporates its response to defendant's motion to dismiss for violation for attorney-client privilege as part of this response. So it sounds like we're going to get something bigger on this particular issue. Issue number 3, the fact that Lori Vallow says that Trina K gave me advice on how to avoid a subpoena. This is how Trina K responds. On March 6th, the defendant filed a notice. The state requested that separate notices be filed for each cause number so the state would know which defenses and witnesses applied to each case. On March 7th, the state learned that defense noticed witness Nate Eaton is a reporter from Idaho. On March 12th, the defendant filed a supplemental notice. March 16th, the state filed a motion to preclude all witnesses on her supplemental filing. So that's a lot of words. But basically, the state filed a motion to have the people on that witness list precluded, not included to witness, to testify. At the final trial management conference on March 18th, the court heard from parties on this motion. The state advised that it did not have contact information for most of the witnesses. The state also advised that one of the defense witnesses, me, was a reporter. Nate Eaton contacted this prosecutor. I missed the page there, sorry. Nate Eaton contacted this prosecutor after court on March 18th, and this prosecutor called Mr. Eaton back. Mr. Eaton advised this prosecutor that his knowledge about the case was from his interviews and investigation as a reporter. Mr. Eaton also advised that he had not been served with a subpoena by the defendant and he hoped to be in court for the trial. The prosecutor advised Mr. Eaton that even if he was not served, he still could not be in the courtroom if he was a noticed witness, and the rule of exclusion was in place.
So you hear that? So he has not been subpoenaed yet, but just being on the list would be enough to bar him from the courtroom. That'll be really fucked up. And he's right in his filing that she would only be doing this to keep him out of there to report on it. Because he has no knowledge. He doesn't know anything about it. What would he know about it? And she has on her witness list her family and Tylee's friends, which, Colby said was really ridiculous, that he thinks she would just want to have them up there to say, did I take you guys to Disneyland or whatever, It's basically character kind of stuff. It's all of her witnesses, from what I can tell. She doesn't want Kay in there, though. That's going to come up.
The prosecutor advised Mr. Eaton that this prosecutor would try to interview the witnesses and file a motion to preclude those that should be precluded at the end of the next week, which would be this week. The prosecutor did not advise Mr. Eaton how to avoid service of the defendant's subpoena. So what I can tell you based on both of those responses, that Ms. Kay's response is accurate. For one, Lori Vallow Daybell said that on or about March 11th, Trina Kay
Right.
gave me legal counsel. I have never spoken to Trina Kay in my life before March 18th. So that is wrong, on or about March 11th. I did say on Courtroom Insider that I had spoken with prosecutors and defendants. I did not say where those prosecutors and defense attorneys work, but I've spoken with several, not necessarily in Arizona or in Idaho or in other states. So we will see what happens with that. My hope and my plan, of course, is to go to this trial and to be there every day covering it. And there might be more to report about that angle coming soon. But I have reached out to the defense attorney, Lori Vallow, and the defendant herself, Lori Vallow, about what more they might want me to testify about. And I have not heard back from the defense team. Okay, so that's one file.
So stupid.
A lot there on the witnesses and what we can expect. Now, let's jump over to the other filing that was had. This gives us kind of some insight on what the trial is going to look like. And we've got it up here on the screen. It's the state's amended final trial management conference statement. Basically, this tells us kind of what the state's going to do. Let's go through it. So here we have the state, the charges that the jury is going to be read. Let me make this bigger for you if I can. Whoops. Instead, I'll just turn it upside down. Okay. I think if I go over here. Well, anyway, I hope you can see it. Here we go. Maybe.
I know, right? I don't either.
There we go. The charges and the sentencing range for Lori Vallow is she's charged with one count of conspiracy to commit the first-degree murder. The possible sentence is life without the possibility of parole or 25 years. Life without the possibility of release on any basis until the service of 25 years. So the minimum will be 25 years. She could get up to life. The settlement status, there has been no offer of a plea agreement. There have been no settlement conferences that have happened. And are the defendant and state willing to discuss further settlement? No. So Lori Vallow is locked into this trial. If she wants a settlement tomorrow, it sounds like she's not going to get it. There will be 12 jurors and 4 alternates. List of potential witnesses for the state. We have the list. From the Chandler Police Department, Daniel Coons, who's retired. Nathan Duncan, we have heard from him. He is a detective. He testified in Idaho. Marissa Francisco, Jason Hunsaker, Robert Crotham, he's retired. William McDonald, Nathan Moffat, we've heard from him as well. Ariel Werther, we heard from him. Erwin Weirbicky and Cassandra Younglin, we heard from her in Idaho too. From the fire department, Kent Keller and Scott Cowden, I believe we heard from them in Idaho, at least one of them. From the Department of Public Safety, Jeff Moberg. From OME, the medical examiner, Dr. Derek Baumgartner. From the Office of the Inspector General, Mark Sari, we've heard from him. From Banner Life Insurance, Robin Smith Scott, she's the custodian of records. So there's all of the officials that could testify in this trial. The civilians include Christina Atwood, Adam Cox, Nancy Jo Hancock, Serena Sharp, and Kay Woodcock.
So what's kind of weird here, so Christina Atwood, Adam Cox is her brother, which he's on her list also. I don't know how, I guess that's, I don't know. I'm just curious about I'm surprised at I'm surprised that Melanie Gibb or Melanie or Zulema, I'm surprised that none of them are called as witnesses. Okay, so it appears that this Atwood person, wait, hold on. Okay, I'm just kind of looking at who these people are that are on the list. I don't know. I mean, we know who Kay Woodcock is. She's trying to keep Kay out of there. Somebody else, too.
It's estimated the trial will take 5 weeks, and this is the statement of the case that will be read to the jury. The state alleges that on July 11th, 2019, at approximately 7:37 a.m., Charles Vallow arrived at 5531 South 4 Peaks Place in Chandler to pick up his son from the residence where his wife, Lori Vallow, Lori Daybell, was living. The state further alleges that Lori Vallow Daybell conspired with her brother, Alex Cox, to kill her husband, Charles Vallow, so she could marry Chad Daybell, and obtained money from Charles Vallow's life insurance policy and from Social Security. Special joy voir dire questions will be filed separately. That's where they go in and they question the jurors, and then juror instructions plus the original ones will be filed separately. So there you go. It's going to be 5 weeks. Could be less, could be a little bit more, but around 5 weeks. We know who the state's going to call, 21 potential witnesses. Lori Vallow, I think on her list, had 11. Well, but she didn't even include her expert. So that's what you've got there. Something to think about. And in a minute here, we'll talk about what the day by day will look like in court. Okay, now I want to go through some court filings that Lori Vallow has filed herself, more of them. You can see they're handwritten with her own pen in the jail cell, most likely. These are the ones that she wanted to file, where she says that these 3 people should not be allowed to testify. Their names are, as you can see here, Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. We request the state be ordered to exclude the following witnesses. Facts. The state's witnesses listed above are not for factual testimony. They are only here to offer speculation and hearsay. Then she goes on to quote some law, federal rule of evidence, that the witness has to have personal knowledge of the matter, and that the rule would prevent testimony of the subject if hearsay, because there's no personal knowledge. She's claiming that these people have no personal knowledge. She quotes a bunch of other case law, a bunch of other cases across America. And then she ends with the state's witnesses above. Let me see what that. I don't quite know what that word. The state's witnesses are meant to deprive the defendant the right to due process and right to a fair trial. These witnesses will not be testifying to facts, but opinion, speculation, and hearsay, creating prejudice and bias for the defendant in front of the jury. In conclusion, the defendant requests the above listed witnesses are excluded from testifying at trial, since it was discovered in pretrial interviews that these witnesses have been communicating with each other regarding the defendant in these cases. None of these communications between these witnesses have been turned over to the defense from the state. And it was discovered by the state, they're saying, or by the defense in these pretrial interviews, that much of the information these witnesses gave in their police interviews was gained from speaking to Kay Woodcock. Long before they were interviewed by police, all three of the above mentioned witnesses should be excluded from testifying.
That's exactly right.
Trial.
Two skulls. Yep.
Then the prosecution responded to that, to Lori's request to have them excluded. And here's what she said. Here's what the prosecutor said. The state of Arizona, through undersigned counsel, requests the court deny to exclude or preclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. Defendant argues in her motion that the witnesses are not there for factual, they're only there to offer speculation and hearsay. The defendant writes, among other things, that these three witnesses lack personal knowledge. The defendant seems to argue that therefore the witnesses are not relevant and should be excluded. And then it says, state presumes defendant means precluded. The state disputes these allegations and provides that these objections are more properly raised at trial, not by a pre-trial motion. The defendant is charged with conspiracy to commit first-degree premeditated murder. The state can use both direct and circumstantial evidence to establish that the murder was premeditated. The courts have long held that although motive is not an element of homicide, it is relevant. And then they quote case law. The state submits that the motive for this murder is that Mrs. Vallow, now Daybell, wanted to kill her husband so she would obtain the proceeds from his life insurance policy, Social Security benefits, and be free to marry her current husband, Chad Daybell. Each of these witnesses is relevant to establish premeditation and motive. The judge has not ruled on this yet, at least as of this taping. It's possible that he ruled on it late this afternoon, but haven't been there. All right, stick with me. I know these are a lot of documents. We're about halfway through. I hope you find this interesting. So that's what we have for the court documents that have been filed thus far. We have a few more to talk about, including this one, which is pretty interesting. Lori Vallow, of course, filed a motion saying, I want all the evidence. We talked about that a bit earlier. And she is now saying here that the state of Arizona, or the state is responding that the state has advised that it intends to admit evidence that the murder was committed for financial gain and to allow the defendant to marry another person. So they're going to argue that Lori not only killed Charles to get money, but so that she could marry Chad Daybell. The state will admit evidence to prove the murder was premeditated, it was pre-planned, and to show the motive for murder was to obtain the proceeds from a life insurance policy for Charles Vallow, Social Security payments for her surviving child and herself as a mother, and to allow her to marry the person with whom she was having an affair. Evidence of the premeditation and motive will be shown through witnesses and iCloud documents. The state will call a witness from Banner Life Insurance Company to show that the defendant contacted the victim's insurance company within 4 days of the murder of her husband to collect the proceeds she believed she was the sole beneficiary of. During this recorded call, she provided a different story about how her husband died by telling the life insurance representative that her husband's death was an accident. She told some people it was a heart attack, some people it was an accident, when really he was shot and killed. When the defendant learned she was not the beneficiary, she advised the person she was having an affair with, quote, So I talked to the insurance company. He changed it in March. So it was probably Ned before we got rid of him. They can't tell me who, of course, but it's done.
See, she's definitely, yep. Yeah. Well, that's just it. You know, they didn't just want to be together because neither one of those two were ever financial providers for their families. You know, Tammy worked, not Mantix. They wanted to go live in Hawaii, and, you know, who was going to pay for it? You know, when supposedly they were going to prepare for the second coming, that had to happen in Rexburg, if you recall all that. So I don't know how Hawaii fit into their end of the world plans, but yeah, that's what it's all been about. Money. She's so gross.
I'll still get the $4,000 a month from Social Security. This statement by the party opponent about the life insurance proceeds is evidence of the premeditation. The defendant later contacted the sister of Charles Vallow to confront her about the fact that Charles Vallow changed his life insurance policy. The state will present testimony from an investigator with Social Security Administration and iCloud documents to show the defendant was aware of how much money from Social Security she would receive from her son JJ and herself as a result of the death of Charles before she went to speak with anyone at Social Security. This testimony and evidence further support that the defendant premeditated the murder of her husband. The state will present testimony from witnesses who were friends with the defendant and iCloud documents to show that the defendant used her religious belief system as a way to justify the premeditated murder of her husband, Charles Vallow. These witnesses and documents were disclosed to the defendant on December 12th, 2023, January 9th, 2024, and February 26th, 2024. So we kind of get a little preview there, a little trailer, you could say, of what how the prosecution is going to take their case. We've heard a lot of this in Idaho, of course, and as we saw on the witness list, we'll hear from a lot of the same witnesses. We'll hear the phone calls in a couple days on Courtroom Insider. I think early next week, I'll kind of go through some of those calls and the testimony that we've heard before that will be played again, I believe, at this trial to help this jury understand what exactly was going on here in the lives of Lori Vallow and Charles Vallow and Chad Daybell. Okay, so now let's talk about some other documents Lori Vallow has filed about what she wears and how she is treated in the courtroom. She's had on handcuffs and ankle shackles every time. And as she said last time, a shock vest, which was kind of news to me. I didn't
remember
know
that
those
shock
things
vest
existed, to be honest with you. But she has now filed a motion in her own handwriting again about what she hopes will happen at court. And that she wants to wear normal clothes. Let's dive in for this one. Lori Vallow requests this court wear civilian clothing during court proceedings, jury selections, and all trial proceedings. The public and prospective jurors are viewing proceedings on worldwide media, hopefully just East Idaho News. No, just kidding. But you can watch it on East Idaho News, by the way. The defendant's appearance is if in jail uniform will constitute a violation of the defendant's due process rights. And then she quotes the Sixth Amendment. The state or Madison County's failure to adhere willfully or inadvertently would deny and violate the defendant's due process rights. Therefore, the defendant requests that the court order to allow the defendant the fundamental right to wear civilian clothing in all court proceedings, jury selection, and both trials. Then she files another motion. I'm just going to scan through it here. The defendant requests the court allow the defendant to have no restraints, handcuffs, or shackles while in the courtroom during all court proceedings. This request is made pursuant to the 14th Amendment, 5th, 6th, and 8th Amendment. On December 6th, the defendant was granted self-representation. It has been extremely difficult for the defendant to manage files, take copious notes in all pretrial hearings with handcuffs. It would be impossible to represent oneself at trial under these conditions. Also, the defendant's appearance in restraints, handcuffs, or shackles violates her due process rights. It impedes her ability to perform writing tasks in her defense. If the defendant is going to properly be allowed to, quote, defend herself, she must not appear separate or different from the state representative. To be able to stand, walk, move about the courtroom as the other attorneys is imperative in a fair trial. If any imposed Madison County Sheriff's Office restraints cause this defendant to appear to the jury different from the state's representation, it would violate the defendant's due process rights and the right to a fair trial. This defendant's documented behavior for the last 5 years while in custody warrants no restraints necessary during trial at all. This defendant has been through a long trial without any misbehavior at all. This defendant has only displayed stellar behavior all of the time
other
she's been in
representative,
custody and incarcerated over the last 5 years. Therefore, the defendant requests that all security restraints be waived for this particular defendant. The defendant also requests the use of a pen at her trial table to take notes. At the minimum, the defendant requests this court to order the state and the sheriff's office remove restraints, handcuffs, and shackles for all trial proceedings, both trials. Well, Lori is right in the fact she has behaved at all court proceedings, and she didn't cause any issues in Idaho. She wasn't, I don't believe she was handcuffed in Idaho. I'll have to go back and check. I can't believe I don't remember. There's been so many of these hearings. If you were there, let me know in the comments if you remember. So here's the thing. The judge on these, the judge already ruled on the clothing, and he said she could wear normal street clothes during the trial and jury selection, but all other hearings she can't. She has to wear her outfit, from the jail.
Right.
The sheriff actually responded to her request with this as far as the shackles and the clothing. The sheriff said the judge already ruled on the clothing, no use for, talking about it. But talking about having the handcuffs and the shackles removed, this was pretty interesting. The sheriff said, and let me pull this up over here. There we go. In the defendant's case, the sheriff's office has reviewed her request and recognizes that she needs to move about the courtroom. However, pursuant to policies and procedures and the sheriff's office duty to maintain control and custody of inmates and to ensure the safety and security of the courtroom, the defendant cannot go unrestrained. As such, the sheriff's office recommends the use of a rack vest, and in addition to the detention officers in the courtroom during defendant's trial. And I think they mean an addition, like having more deputies in there. The rack belt is designed to temporarily stun an attacking detainee, thus buying time for courtroom security officers to react. The belt sits comfortably on the defendant with straps adjustable to a particular defendant's body type. The belt is not visible to the jury. Further, the belt works on a one remote, one sensor system, ensuring that activation of other remotes will not trigger the vest accidentally. These two security devices permit the sheriff's office to restrain defendants in the courtroom. Without any restraints, we'd have to recommend an unarmed detention officer and an armed sheriff deputy in the courtroom. And then the sheriff said, after reviewing her motion, I have the following recommendations. Normally, inmates attending a trial wear a leg brace and a rack belt around their waist, which allows detention officers to deliver an electric shock by remote control. These two devices are worn under the clothing of the inmate and are not visible to the jurors. Handcuffs, leg chains, and inmate uniforms are not worn while in the courtroom. She has been wearing handcuffs. And this is done specifically to prevent jury from knowing the defendant is currently an inmate.
Shackles.
Okay, so it sounds like during trials, they don't wear the handcuffs. The jail staff maintain control and custody of the inmates during transports to the jails and all back and forth. Once an inmate leaves a secure jail facility, all inmates are restrained while outside the facility. In this case, they could remove the restraints while she's in the courtroom, and she could wear that rack belt and vest, which isn't seen from the jury, and a hidden leg brace to limit mobility. And so they're saying maybe, she can see because she's her own attorney, she needs to move around. She might not need the leg brace, but there's no reason that she wouldn't need the rack belt. So that's pretty interesting. I did not know about this rack belt. I don't know if I've seen that in Idaho, but I'm going to check, and maybe we'll do a story on what is a rack belt. And I don't know if it's like a taser, if you feel a little jolt or something.
Right? I know. A muzzle for sure. So, looks like she's going to wear clothes. and this belt thing. I never really thought about it being up to the sheriff, but then again, they are going to be the ones responsible for, security, obviously. So, and although she didn't do any of these acts herself, she was definitely, calling the shots or whatever you want to call it. I don't know. But so I don't know what else is she's going to try to pull before Monday. Like I said, the judge already told her at the hearing I was at, she was already late at that point. She should have filed this stuff before. Yeah, she asked for a pin. Isn't that weird? Who knows? I mean, who knows with this one? She's so nuts. She's just crazy, crazy, crazy. I'm not going to plan on, well, they're not going to stream the jury selection. So my idea is, it's going to start like they say on the 7th. Realistically, that's when it'll start. The actual trial. So I will, we'll plan on that. I guess we'll have to play it by ear. I guess could go a little less time, a little more time. But there is no court in Arizona on Fridays, apparently. And court starts, I think, at 10:30. That's late, right? No, exactly. She has nothing to lose. She doesn't. Absolutely not. Yeah, she does not have anything to lose. I mean, she's already got 5 life sentences in Idaho. So, exactly right. But, so that's where we are with that. And when will we get any answers on this? I guess the day of the next week, I guess. I mean, yeah, that's exactly right. It's exactly right, Queen. 100%. So, anyway, okay. So I've been working on some projects. I will be I should be done and be able to show you guys maybe later this afternoon. Guards are smart enough to go through her hair. Right. She's got a shake. Oh my God. I've got I'll show you guys some stuff I made for Easter for the grandkids bags. That's for teenage grandson. Made these ones for Shabby's grandkids. I don't know if you can even see them. Not that anybody really cares. Granddaughter. Look at this one for my little my girl. And this one's so cute. I don't know if you can even see. For baby Dan, I messed a bunch of these up, but I know. Look at that's for Jack. Another granddaughter. I have a couple more that I messed up that I melted the bags, so you can't have to redo them because this stuff you have to put something over the top. You can't let the iron hit on this. And on one of them, I just let it accidentally because I put like parchment paper over it all. But then on one, I had it too hot, you know. But I'm working on bags, some different kind of bags for this trial. So I will show you those. Not done. I've cut most. I cut all the vinyl. I just need to get it on the bags. So, and so I was thinking I would go and get my nails filled and and get a Jeremiah's and come back live. Yeah, I'm gonna go really quick though. I just want to ask anybody real quick before I get off here. Has anybody heard of a hummingbird cake? Just very curious about that. Because I had never heard of it. But oh yeah, I actually knew that. My nails, I've lost 3 nails. Yeah, they're bad. They're bad. Okay, well, just so you know, my daughter-in-law's birthday was Tuesday, and so we were going to dinner over there at their house. And so I told my son if he wanted me to get a cake or make a cake or something. And he said, well, she wants a hummingbird cake. And I said, well, I've never heard of that, but I'll check it out. Yeah, they're not. When I tell you I spent the entire day Tuesday making that cake, I am not shitting you. It was the whole day. Yeah, it's got bananas and pineapple and all day. I'm so glad I got started early in the morning because we were actually even a few minutes late to their house for dinner because I could not. Oh, I have a picture. I have pictures. I forgot. And I really had it in my head I was going to make it really pretty. That didn't happen. Now it did taste very good. But apparently the night before, she said something to Travis about a cake. And he said, oh, my mom's going to make it. And she was like, make what? And he's like, that hummingbird cake. And she's like, oh my God, no. She goes, I was kidding. She goes, I thought you were acting like you were going to make a cake. She goes, I don't want your mom to do that. It's a lot. And it is. I'm glad I did it. But wow, that was a little bit of stress. Little bit of stress. Nope. I roasted the pecans. I did. I know I thought I was going to decorate it. But I mean, so there it is. I just thought I could make it look prettier. It did taste really good. A lemon jello, that's. Oh yeah, that will be. I love lemon. That's just it inside the cake thing. Yeah, it tastes really good, but holy moly. Probably not going to be making more of those. Really? I did see Lisa. Lisa was there. She looks really good. Oh, wow. That actually sounds super good. Remember that cookie I got at Crumble that was lemon poppy seed with blackberry something? Oh my God, that was the best damn thing. I think about it a lot. Oh my God, you guys. Did I tell you this already? I did, I think. Right, Frazzle? She does. I told you guys that Mr. Snotty made me a tomahawk, right? Yeah. So good. Oh God, I love that place. Oh yes, so good. I told him that morning, I said, I want like Flintstones. I want to take that, hold that bone and just, it's a lot though. We only cooked one and we haven't been able to eat it all. It's actually a lot. So good though. Very, very yummy. But okay, I'm going to run. I'm going to come back on in a little bit and show you guys that stuff. There was something else I wanted to do. I can't remember now, but I'll figure it out. I think so. Right, Mama? Oh, gosh. It was so good. Oh, God. I got a picture of Mr. Snotty trying to... After we cut it all off, the bone. That's a big old bone, man. It's good, huh? Yes. Happy birthday. You are very welcome. And I hope you have a great evening. Great rest of your day and a wonderful evening. Good dinner. Sounds like you're going to have yummy cake. That's already all handled. Yes, you are welcome. Have a wonderful day. And I will see you guys back here in a few hours. Okay. Thanks so much, guys. Bye. Oh, yeah, I know. We need to check on the birds. That's what I wanted to remember to say. Yeah, we'll do that. All right. Bye, guys.